Good morning, everybody. This is Omar Serrano with the Tilted Lawyer podcast, verifying that sound is good. Sound looks like it's good. We are here. The trial has started. Sarah Boone trial is underway. They just concluded opening statements. They're actually moving into some testimony, and it's go time. So I have some thoughts on this particular live. Now, look, we're going to be doing daily coverage of this Boone case. We're not going to be streaming live during the trial, except for today because it's Friday, and this is just the time we stream. I'm going to review and give you my thoughts of what has gone on with the opening statements, give you my impressions of these attorneys that are litigating the case. They are not the theatrical type. That's for sure. I certainly have thoughts about the defense attorneys. Now, look, it's there's been a lot of opinions about the efficacy of Boone's defense attorneys, but you have to understand they're coming into this case with maybe a month worth of prep. And look, I'm not trying to make excuses for them. It was their dumbass fault for taking on this trial, but here we are. The prosecution, on the other hand, has been sitting with this evidence for 4 years now. And so if there is a deficiency in preparation appearing from Boone's attorneys, I mean, it's not that they're going to be given any grace, but there's a reason why it's like that. I can tell you that I think that Boone's attorneys are competent. I don't know if they're any good, but they are certainly competent. They're going to look a lot worse than they are, and it's simply because of the preparation issue. They gave their opening statements. They have outlined their theories of the case, and I can tell you from my perspective that, let me get rid of this. I can tell you from my perspective that there is a real good chance that Boone's stated defense is going to get blown out of the water unless the evidence supports a couple of things, and I'm going to tell you what those are after this.
Whatever you might be going through and wherever you might be, this is Omar Serrano with the Tilted Lawyer podcast. I'm here to take your mind off of things. Yes, I'm an attorney. No, I'm not giving you legal advice. We're going to sit and talk like people, as these are the candid thoughts of one practicing attorney, and it's after hours. So have a seat. Feel free to have a drink and join me. Let's get started.
So listen, there's a lot of coverage of this case, and what I'm not going to do, because I haven't the time to do it, and I suspect if you're watching my stream, all of you don't have the time to sit there and go through line by line every single pretrial motion that has been presented and argued with the judge. But we learned some things. And what we learned, let me just make sure this isn't any of our upcoming guests. We learned some things in pretrial motions. And just to sum it up, basically, the prosecution was objecting to the 550 pages of exhibits that the defense had presented as possible exhibits in the case, and they wanted them to whittle it down. The judge wanted them to whittle it down because what are we trying to introduce the rounds that the nurses were making when Torres was being treated with COVID? What are we doing? How is that relevant to the case? Their arguments have been, well, Your Honor, I don't know if it's going to be relevant or not. We are simply presenting it in the off chance that it might become relevant. Now, look, it's fine to do that, but usually the way that comes up is in the form of impeachment. So if through the testimony, something raises an issue related to that discovery, then you could bring it up as impeachment, regardless of whether or not it was on your exhibit list. It's already been exchanged. And so the question was what are they sitting there offering it as an exhibit for? So those were mostly the objections, but more interesting than that. Look, the evidentiary stuff is going to be the evidentiary stuff, and we're going to sit through trial and go through that in real time. And so a lot of those pretrial motions were kind of moot on the prosecution's end because it was look, he sustained some of it, but most of it was look, if during the course of trial it becomes relevant, then I'll let you do it. But if foundationally you can't get this in, you're not going to get it in. Everybody understands that. They being the defense, offered a defense of battered spouse syndrome, which is risky because it is by its nature a self-defense case, which means you are admitting that your actions caused the death of trial. Now, they're put in this position because in Florida, when you're charging somebody with second-degree murder, you don't have to prove intent, which is problematic because, as you heard her say thousands and thousands of times in interrogations and in her pretrial motions, none of this was intentional. It was an accident. How was I supposed to know that he was going to die if I left him in the suitcase? She said that over and over again. In Florida, it doesn't matter. It's a depraved heart murder. Basically, if you engage in dangerous conduct that leads to the death of another, you can be found guilty of the murder. And that's the theory that the state is progressing on. Now, by her asserting battered spouse syndrome, she is asserting that, yes, okay, I killed him, but it was self-defense. So a lot of these motions have been centered around the issue of you can't really claim self-defense if there was not an overt act that made you believe that you were in imminent danger, which would have required self-defense. And so in the evidence, there hasn't been proffered anything, any modicum of evidence that Torres engaged in an overt act that would have led a reasonable person to believe that they were in danger. So if the prosecution, well, check that. If the defense is unsuccessful in laying the foundation that there was this overt act that led to the need for self-defense, then they're not going to be able to use it, and they will have no self-defense. They will have no defense at all. It's like an open and shut case. Their theory of the case is this. They have deposed expert witnesses that have examined Miss Boone, and in the course of their meetings with Boone have rendered opinions about how she might have been in the state of mind of a battered spouse, where she truthfully and in good faith believed that she may have been in danger. What is the overt act? If you listen to the defense a couple of days ago, they gave their motion, and essentially what they said was she had endured abuse over the course of years with this guy, Torres. They were playing hide and seek, and she goes and hides somewhere, and he hides in a suitcase, and she manages to trap him in the suitcase. And in the course of doing that, she had this trauma response where she remembered all of the times that Torres had abused her. And if you listen to the first couple of witnesses today, they were straight up saying that, it sounded like there was like a scuffle going on, and there was a phone call with Torres's brother who took the stand and said that Sarah was talking about being choked, meaning that, look, the whole thing was like, this is what it feels like when you choke me. That appears to be an incident that occurred right up around the incident leading to Mr. Torres's death. So it's valid if there was a domestic violence incident right before the suitcase incident, that she might have been triggered by that, and it triggered all this other stuff. So she's taunting him, and she's feeling high and mighty because she's properly lubricated on alcohol, and she's taunting him and making fun of him. At some point, according to the defense theory, Torres tries to put his fingers through the zipper hole to unlock himself, and then Sarah hit his hands with the baseball bat. So she's doing all of these things and kicking him around and flipping him over and doing all of these things. And she gets it in her mind. It's like, well, holy shit. Now what happens when he gets out? He's going to whoop my ass. And it is that belief that they are trying to stretch this overt act to allow them to argue the battered spouse syndrome self-defense theory. That's what they're going with. The theory is, because she had done all of these other things and she locked him in the suitcase, she believed that if she let him out, that her life was in peril, and therefore it was self-defense to leave him in the suitcase, and that led to his death. That's how they're trying to fit this in. So if you didn't know before, that's the theory that they are operating under. The prosecution has been trying to get rid of that because they're like, bullshit, that's not how self-defense works. You can't, one of the analogies that the DAJ had outlined is like you put a dog in a crate, you lock him in there, and then you decide not to let him out because sometime in the past, the dog had bit you. That's just not how this works. It's not the same thing as self-defense. So I have been concerned with the defense's strategy under how it plays out under Florida law. If the jury doesn't believe that there was an overt act, and good luck with that, it's not going to fly. They're not going to be able to use that as a defense. In other words, if the jury, when they are deliberating, decide that, look, there was no overt act, and so therefore self-defense doesn't apply, and that was the only theory of the case presented, then she's just guilty. Keep in mind that she's facing a minimum of 22 and a half years in jail as a result of this case. She was offered a plea deal last week whereby she would have been out in like 5 years, 5 3/4 years, just under 6, for credit for time served and good behavior at the 65% clip, as is mandated by Florida law. She rejected it because she's an idiot. So here we are, we're in trial. Now, the attorneys in this case, when you are arguing in front of a jury and it's a 6-person jury, there's 6 jurors and 8 alternates, theater matters, presentation matters. And so if you have a charismatic prosecutor or a defense attorney, they are greatly advantaged insofar as they're going to be able to connect and relate to jurors. Trial is all about being relatable. Trial is not about demonstrating how smart you are. It's not about Magnum PI. This isn't the Lincoln lawyer. This is not what you think trial is supposed to be as you've seen it on TV. It's about how you connect and engage with the jurors. Usually, the attorney that is able to best present himself as a credible truth teller with an ability to narrate a story skillfully through direct examination and cross-examination, through how you present your case, the jurors are going to very quickly pick who they can trust. And if it's not you, then you're dead in the water. You might not be dead in the water, but you're facing an uphill battle. My impression of these attorneys is that I believe that the defense attorney, he might not be the most charismatic guy in the world. He's quirky for sure. I think that there is a world where you would see him in the courtroom and you would see, wow, that guy's really good. I want to hire that guy. But in this trial, he's been getting his ass kicked because he's unprepared. And it's not really his fault. I mean, it is because he took the case, but he's literally had since August, the end of August, to prep for this trial. And the prosecution has been sitting on this evidence for 4 years. And so there is going to be a wide gap in experience level with the evidence that is, the evidence that is coming in, and even the evidence that can't get in for various reasons. And the fact that you've seen the defense present their exhibits, which none of us have really seen, by the way, leading up to this trial, the fact that he's just kind of throwing everything at the wall and hoping that something sticks is evidence of his inexperience with this case, which puts Sarah Boone at a grave disadvantage. Because the jury, like I said, if we're going to pick somebody who we're going to trust, we're going to pick the guy that knows the evidence best. If on the charisma scale, they're both equal. It appears to me that they're both equal. I would not, for example, listen to the DA in this case and like, oh, wow, I want to go have a beer with that guy. Or I would totally hang out with that guy. The defense attorney, honestly, I'd probably rather go. He probably has a lot of good stories to tell. He's an older guy. And he comes off as relatable to a degree. He's quirky. But I wouldn't distinguish them on a charisma scale just simply off of appearances. Now, he's being helped. He's got a buddy who appears very subtly brilliant. And he's helped a great deal in arguing the motions in this case and outlining the defense's strategy of presenting their battered spouse syndrome defense. And he speaks very slowly. He's an older gentleman, but he speaks with a lot of conviction, and he poses very smart retorts to objections, and he comes off very well. And he's been involved heavily, and I think he's going to help out the defense a lot in this case. The DA is just kind of on his own, and he's doing, I mean, he's got a whole office behind him, but he is basically, it appears, the only guy that's going to be presenting in this case. So I'm going to break down these opening statements. We're going to rush through them. They weren't that long. They're about an hour long in real time. We're going to speed through them at 1.5 speed. I'm going to give you my thoughts. And together we're going to try to dissect and understand their theory of the case. Now, look, today is day one of trial, of probably a 2 or 3 week trial. I'd be surprised if it went any longer than that, although it may. And I'll give you my thoughts and impression. I'll give you who I thought came out on top. I can tell you this. First impressions. The defense's opening statement was just abysmal. Abysmal in that, I mean, if I were to grade it, I'd give it a C. But what I mean by that is the guy appeared nervous. It didn't really make a lot of sense what he was saying. He didn't really make any impactful statements that I thought was going to sway a jury. If you're talking about just credibility in terms of opening statement, I thought the prosecution's opening statement was more effective. But we're going to go through it together because that's what we do. So let's get through this. I'm going to offer my thoughts as we're going through it. And if you guys have any questions, for sure, leave them in the comments. I'll try to get to all of the comments as best I can. If you really want to get my attention, the best way to do that is to leave a super chat because those pop up and ring in my ear, and I will read your comments on air. Otherwise, I'm going to do my best to get as many of your comments in as I can. But let's get through this because, hey, it's a big day, man. Opening statements in the Boone trial. So let's get right into it. What did I do? Where did it go? Here we go.
Proceed with opening statements this morning. Both the state and the defense will have the opportunity to present them. I ask that you listen closely to those statements that they're going to provide. But remember, these are not evidence. This is just the party's belief as to what the facts and the evidence will show in this case. After the conclusion of the opening statements, we'll begin with the state's case in chief through witnesses. With that, Mr. Jay, you may proceed, sir. Thank you.
Now, folks, there's going to be difficulties hearing these attorneys because they're not really speaking into the mic unless they're standing at the podium. So you're just going to have to do your best. I left the captions on to try to help out. Well, let's just see how this goes.
Gentlemen, what the evidence in this case is going to show you is that this defendant zipped Jorge Torres shot in a suitcase. She was able to do this because at the time of his death, he only weighed 103 pounds. And she did this with the malicious intent to punish him. And then she went up to sleep and left him to take his final breaths on this earth alone. How many breaths those were, we don't know. The evidence is going to show that it was at least for about 15 minutes, because there's going to be 2 videos that the defendant herself took of this event. Evidence is going to show Jorge Torres is dead because in this defendant's judgment, he deserved it. Now, with conscious disregard for whether he lived or died, you will see and hear these videos. What I expect you will hear from a video that began at 11:12 p.m., 45 seconds.
There we go.
On February 23rd, 2020, in Orange County, Florida, is a suitcase on the ground, face down, with the zippers facing the floor. You will hear, Sarah, the defendant will say, for everything you've done to me. Sarah, for everything you've done to me. Sarah, fuck you. And then the defendant laughs. Sarah, fuck you. And the defendant laughs. Sarah, stupid. Sarah, that's my name. Don't wear it out.
It's always hilarious to me when lawyers curse in the courtroom. Most lawyers do not. It's just always this awkward thing. You either know how to curse or you don't. This guy, well, it's just coming off a little awkward.
Sarah, I can't fucking breathe, baby. Seriously. Yeah, that's what you do when you choke me.
It's like
Sarah.
Mr. Magoo saying the F word.
Sarah. Sarah. The defendant laughs again. Sarah, I can't breathe, babe. She laughs again. That's on you. Sarah, I can't breathe. She laughs again. Unintelligible words. And I would submit the evidence is going to show, because of the intoxication from alcohol, is the next thing she says. Sarah, I can't breathe, baby. That's what I feel like when you cheat on me. Sarah, fuck you. I can't fucking breathe, Sarah. You should probably shut the fuck up. Sarah, shh, is the last thing you will hear the defendant say to Mr. Torres as he is face down, zipped shut in a suitcase. That, again, began at 11:12:45 and lasts just over 2 minutes. At 11:23 and 3 seconds p.m., there's a second 22-second video, and it's the defendant zooming in on the suitcase. And all you hear during this 22 seconds, after he's been in the suitcase since at least 11:12 p.m., is one more time, Sarah. How did we get to this point where 103-pound Jorge Torres is putting this suitcase left to down? Well, the next morning, the defendant wakes up, late morning, perhaps early afternoon, somewhere in this time range, several hours later. And she goes downstairs, and she doesn't see Jorge anywhere, Torres, and eventually realizes, oh my God, the suitcase. The first thing she does after taking him out, and I believe you will hear a description by the defendant saying, took his little legs out. At some point she makes that statement, and tries to resuscitate him. Here's gurgling as she presses down on his 103-pound chest, forcing whatever air was trapped in there out and gurgling.
Now, 103 pounds. I mean, I've been following this case for 4 years now. I don't know how it escaped me that the guy was only 103, 105 pounds. Sarah Boone looks to be about 145. That physical description is going to be important. The size differential matters. And I'm really curious about how they're going to present those differing physical descriptions. From the defense standpoint and from the prosecution standpoint, I feel like it's going to have an impact on the jury.
The next thing she does is she will call 911. She calls Brian Boone. Brian Boone. Brian Boone is her ex-husband. They share a child in common. And this date, February 24th, 2020, is a Monday. A normal work day for most people.
They got to get these people some lapel mics. What are we doing?
But after they got divorced, the arrangement was every other weekend, no co-parent. And that weekend included Friday, Saturday, Sunday. So it's got free schedule. And then Monday through Tuesdays, their child would be her responsibility. And Wednesdays and Thursdays, their child would be Mr. Brian Boone's responsibility. So February 23rd, 2020 was a Sunday. And now he's led into Monday. Mr. Boone had been trying actually to contact the defendant several times that morning because he just wanted to confirm she was going to get their child after school that day. And there had been a history of reliability on that issue on her part. So you will see in the phone record, he calls her.
Initial thoughts, he's talking about custody stuff in his opening statement. I'm not sure how effective that is. He started off pretty strong. You know, the scene regarding Torres and the suitcase, and now he's focusing on custody and visitation stuff. I don't understand the strategy.
Calls her. Then she finally calls him back instead of calling 911. And being the nice co-parent that he is, he comes over. It's a short drive, about 10 minutes. And as she's explaining to him what the heck is going on, he peeks in through the front door of her townhouse, which allows you a view all the way to the back sliding glass door. You're going to see that her kitchen is off to the right, but there's a doorway that you can see all the way through. Then on the back side of the kitchen in the breakfast room area, there's tables and stuff. There's also some blue legs sticking out in view. Brian Boone says, check, please. You need to call 911. He doesn't set foot into that townhouse. He does wait outside, though, being the good co-parent that he has been. So now, after having first called her ex-husband, after having first waited for Brian Boone to come over, the defendant makes the 911 call. What you will not hear
Thank you.
are tears. You will not hear sorrow. You will hear a certain level of concern. My boyfriend and I were playing last night. Put him in a suitcase, and we were playing hide-and-seek kind of thing. I fell asleep. Found him dead in the suitcase this morning. I don't know what happened. He had blood coming out of his mouth. Don't know if it was an aneurysm. Pulled him out of the suitcase, tried to give him CPR. He was in the suitcase, and I fell asleep. He's not awake. He's purple. He's not breathing. There's some instructions about how to do CPR given to her, asking about whether an AED is available to shock his heart. It's too late. He's cold, he's stiff, he's purple. We were playing hide and seek. We were playing hide and seek. This is horrible. This is horrific what happened. Like, what happened? We were playing hide and seek last night and I fell asleep. So she mentions that there was blood coming out of his mouth. And his body, like all bodies in his death, was taken to the night vision that was examined by an autopsy. What the doctor found was what you would expect after being left in a suitcase, crumpled up in the fetal position. He passed from positional asphyxiation, meaning like you're not going to get full breath when you're crumpled up like an organ, and environmental suffocation. You don't have to have a plastic bag over your head, tape shut with a full roll of duct tape to seal it off 100%, be worthy of backing up space. You can environmentally suffocate. It's close enough if you can't get the oxygen and the CO2 coming in and out of your environment. But she also did notice, he suffered from blunt force trauma on his torso, in his face, his mouth. She'll use words like contusion, will help her explain contusions and bruises. She'll use words like hematomas,
Blunt force trauma on his torso.
bleeding under the skin and blood, like you can expect from bruises, that's why they're running through. But it had all this additional trauma.
He's basically saying, I know it's difficult to hear, but he's basically saying that, dude, she beat the shit out of this guy as he was in the suitcase.
You will see and hear that body on camera. It's more of the same as what we heard on the 911 call. I see. It was good. I fell asleep. What happened? A few hours later, the detectives from the homicide unit at the Orange County Sheriff's Office approach her and are ready to interview her after doing some initial things, which includes grabbing her cell phone, off of a counter that was found in a suitcase in Mr. Torres, and giving it to one of their digital forensic examiners, who we'll hear from later in the trial. You know why. But it's time to give the first interview with the defendant. So they do the first interview with the defendant in one of their unmarked detective patrol cars there on the scene. And the basics of this remain the same, but there's a little more elaboration, as you would expect from trained detectives versus getting the 911 call taken. But the basics of what the defendant tells them is we had wine, we painted, we drew, we did puzzles. The particular wine we had was a Chardonnay from the Woodbridge winery. The bottles, plural, are in the trash. We started about 4 p.m. after Mr. Torres went to the store. Puzzles, art, listening to music, enjoying each other's company. We were literally just enjoying one another's company. The other bottle of wine that was left over from Boone wasn't even half full, so the description she is saying is 1 bottle of wine and plus a fraction of a bottle of wine left over from the night before. Ladies and gentlemen, not all bottles of wine are made the same. Many of us may envision what you would expect at a restaurant. Those are 750 milliliters of that. Bottles of wine that were recovered from the defendant's trash can were 1.5 liters, so the equivalent of 2 standard bottles of wine. A 1.5 liter bottle of wine is 50 ounces. Given that a standard serving of wine is 5 ounces, you can begin to do the math. And there's receipts. The day before, Saturday, February 22nd, 2020, there is a receipt from Publix for a bottle of Woodbridge wine for $9.74.
See, sometimes the problem of being a prosecutor, like you have a whole office behind you. You feel like you got all of this pressure, like to get all this information. And this guy has 4 years worth of evidence floating around in his head. All he had to say was, look, she was properly sloshed. Multiple wine bottles, whatever. People will get it. He's like trying to say, a standard glass of wine is 50 ounces. And then blah, blah, blah. Like we're doing astrophysics on whether or not she was drunk or not. Just say she was drunk, man. And then move on. Tell the story. That's my critique about this guy. He comes off like an accountant. There's 2 different kinds of trial attorneys. There's the charismatic storytelling, narrating side. And then there's like people like this guy who's more like an accountant. Like, I'm just going to tell you all the score. This is what's on all of our spreadsheets. And this is why we think what we think. Look, man, you got to simplify it. You got to dumb it down. I hate opening statements like this. He's trying to get too much in.
And then Sunday at 12:17 p.m., there is another receipt for $9.74 for a Woodbridge Chardonnay bottle of wine. And then at about 5:30 in the afternoon on February 23rd, again, there is another receipt for the same bottle of wine for the same price. And those 2 bottles of wine were recovered. They're going to be produced to you in evidence, and you will see that they are, in fact, Magnum bottles of wine. So that's the context that we're dealing with when we hear things like, we only had 1 bottle of wine, and we finished what was left in the bottle of wine from before. Well, ladies and gentlemen, there's 2 1.5 liters that apparently were consumed by a 103-pound man and the defendant, who is in the same weight class.
Arguably, she's not in the same weight class. Matter of fact, some of you in the comments are basically saying that she is what did Saltina say? Boxing weight divisions are a good reference guide here. He was a straw weight and she was a lightweight or super lightweight. Yeah, the difference between 105 and 140 is significant. When I was wrestling, my high school weight as a freshman was 145. And when I would wrestle somebody that was 103, is different. Now, look, there are obviously different genders and different things at play here, but his point is basically 2 1.5 liter bottles of wine. You're going to be properly sloshed. But then again, it's like, why say all of that? Why don't just say we're going to introduce evidence of their intoxication, because he's just going through the receipts. He's going through it in this tedious way as opposed to a storytelling way that I feel like is not the most effective, but I'll let him be the expert.
Plus, if you believe that the defendant and the decedent would leave leftover wine from any given day, any additional wine that was remaining from the 1.5 liters from Saturday. Ladies and gentlemen, that's a lot of wine. So in that context, we were just having wine, enjoying each other's company. At one point, we played hide and seek. She says she didn't zip it up all the way. There was enough room, in her words again, there was enough room for his little fingers to get out. We were still having a good time and whatever. And basically, you know, Mr. Torres is stressing out about jobs, his ex-wife, about money, and so they're just doing puzzles and doing things to keep his mind off of it, doing art, playing with dogs, dancing with the dogs, playing hide and seek. We were always trying to outdo each other where we could find each other the best. When they started playing hide and seek, she went up to the shower and then got tired of hanging out in the shower and came down, and that's when she found him playing around in the suitcase. We both thought it was funny. I'm going to zip you up. 2 little fingers could stick out. And she went upstairs thinking, he'll get out, we're going to have sex and go to sleep and call it a day. It was a good day. She insists that they had wine, but we're not drunk. You will be able to assess that.
I think you're going to, and look, the video evidence is coming in. Nobody's going to listen to that video and believe that, oh, she was not drunk. She was totally sloshed. She was on a good one.
For yourselves when you hear the recording she made. No ill will between us last night. Last argument, maybe last week. Don't really argue. We came home, drink, smoke, did art, listen to music, play with the dogs. We drink what we can afford. We used to be able to afford liquor, but now we can only afford wine. And that's how that day ends with the police. She goes and sleeps and stays at her ex-husband's house the night of February 24th, 2025. What they are doing, and by they I mean the Orange County Sheriff's Office, in part, is her phone. That's when they discovered the 2 videos that I just described for you. And there's other things in the phone, which I will discuss with you in a little bit. But she's summoned in for another interview, and she sits down and gives another interview on February 25th, now Tuesday. She does describe past instances of violence. You're going to hear about that. She's going to say, Mr. Torres had hit her with a curtain rod about a month ago. Since then, though, like, we've been good. I've been good. She describes that he comes at her all the time. He comes at me. So it's either I flee or I try to go upstairs and go to sleep. That's usually what it is. I don't know if you talk to Brian, her husband, about any of that, but most of the time I flee and I go over there. There's a discussion about why she stays with him, and you'll hear that for yourself. She will say that she doesn't really want to drink. She just takes an occasional drink. She drinks to placate him, Mr. Torres. She says that you're going to see phone videos of Mr. Torres smashing her TV in the past, like a month earlier. You may see that too. But she doesn't get drunk. When she drinks, she likes being non-compos mentis. Her words, not mine. Having her wits about herself.
Non-compost mentis? Has anybody ever heard that? Is that a real term? Is that, Dominic, what does that even mean? Have you heard that term before? Non-compost mentis? I have no idea what that means.
Then she gets to the hide and seek again and describes that they've played it 3 times before, but had never zipped one another shut in it before. And they were really just running out of places to hide because it's just a townhome. She does not remember, according to her, she does not remember taking any photos or videos of the night's events. At this point, they ask her, well, would you like to see it? And she says, I can't watch this. I flipped them over, and that's where it was. Guys, this is killing me right now. That's why I flipped it over between the 2 videos. I didn't do anything intentional. Discussion over whether he had enough room to get any of his fingers out from the zipper. My intention was not to leave him there. We both got in there. Both of us were in there. When she went upstairs, my plan was not to, quote, he'll be up here any minute. My plan wasn't to leave him in the suitcase. Why is all this going on? It's the drinking. That's what it is. It's the drinking. I thought he was okay. Guys, that's how we were with each other. Nobody understands our relationship. This whole suitcase thing never happened before, though she described it happened before. I'll never drink alcohol again. She insists that she has no injuries on her, and you don't have to take her word for it because they took photographs of her and there were no injuries on her. She insists over and over that there was no violence that day. It's like, okay, we're in a good place right now. They asked her about saying fuck you to Mr. Torres. Well, that's just being playful and having a good day. Everybody's having a good day. I didn't touch him, nor did he touch me. Her words. What else is found on her phone? There's a conversation between Mr. Torres' brother, and again, nobody knows who's using these phones at the time text messages are sent in these records that you're going to see. But it's indicated that there's a communication between one of the decedent's brothers and the owner of the phone that was taken that belongs to Ms. Boone. The text from the brother is, yo, my daughter told me what you did, Sarah. I don't want you around any of my daughters or nieces and nephews. And that's Christmas 2019, just under 2 months before this event. She replies, or the person using her device at this time, ugh, your quote-unquote dad hit me in the face. The next text is, hide and seek, I shall. January 13th, there's another heated discussion. She describes it on January 13th in a text to Mo, the brother again. It's a Torres thing. Boo, sends a picture. Keep the fugly creep out too. It's still fugly. Lose. The brother responds, please do something with yourself, Sarah. God bless you. The defendant's response, and bless you and all of you too. I'll get, in all capitals, rid of him. Then it'll be, in all capitals, better. Ugh, Torres, referring to Mr. Torres, getting rid of. And that's the case. That's what the evidence is going to show. But we, the state of Florida, and the members of the
All right with this guy.
we're all going to come up to a door that says, danger, keep out, stay away.
He's going to wrap this up pretty soon. And then I'm going to give my critique.
The door, we shall not enter without permission and invitation. Halloween in like 13 days. Part of the vampire lore is vampires can't come get you in your house. Why participate during this trial?
Check out this guy in the back. That is a
Past relationship with the
A+ mustache, man.
And as we come inside this room, at her beckoning, we're going to have things pointed out that she would like us to focus on. And you're going to hear the first night the defendant met the decedent, Mr. Torres, he smashes her phone, punches her. It's the first time in her life she'd ever been punched, I expect the testimony to be. And he made her curl up in a fetal position on her own porch for 4 hours. And she was only able to escape this situation when he fell asleep. I expect that you're going to hear that Mr. Torres is an alcoholic. I expect you may hear his high score on his blood alcohol level was a 3.42 once when he got treated at the hospital. This is a man who has serious alcohol problems, and I expect you're going to hear about that. Despite that first date, and this is going to tie into some other things that I expect could possibly come in. Despite that first date, despite at that point in time of this first date not having a relationship, emotional ties, and the things that come along with a relationship that make it harder to break off a relationship, it's one thing to have a bad first date, it's another thing to end a 25-year marriage. Despite that first date, there's a second and a third. Now these dates are at bar, and there's nothing wrong with that. But it ends up, she's going to tell you, I suspect, or you're going to hear that she said one way or another. It's one thing or the other. Like I asked a dude for a cigarette, Mr. Torres flips out, and I'm going to pay the price. Just things like that. You're going to hear and potentially see, yes, there were injuries that the defendant is going to attribute to the victim causing her. Black eyes, cuts in the face, perhaps from the curtain rod incident that was mentioned in the police interview happened about a month before this. Bloody ear, a stab wound in the leg, which is perhaps described as sword fighting and playing around in that way. But nonetheless, I suspect you're going to hear and see a lot about their past history. And at the end, if this occurs, if this comes in, the state is going to have the opportunity to take lead of the tour in this room, labeled the defendant and the victim's past history. And I'm not going to go into that now. If this all comes to fruit, the blooms on the tree during the trial, we'll discuss it at the end where it's more appropriate. But I'm asking you to not rush to judgments until you hear all of the evidence in the case. And then apply whether or not these past instances have anything to do with what happened on November 23rd. Now, like the home inspector, there are experts to come in and kind of help walk everybody through this room, labeled the defendant and the things that we would hope that you pay attention to during all the testimony, if there is any, about this subject matter. One is that it's not actually a recognized diagnosis in the Bible that they use in mental health called DSM-5. Diagnostic Statistical Manual, version 5. It's text revision, something like that. What it is, and what they describe it as, is kind of a component of post-traumatic stress disorder, PTSD. But because it's not actually in the book, it's like a recipe book. It's like our statute books for lawyers. We go into this book and say how to, a particular disorder diagnosis. It'll say, well, all of us agree that it needs these 3 elements, like elements of crime. Some of these elements have to be prevalent for a certain amount of time, so on and so forth. You have it's a cookbook. Gives you the recipe for a diagnosis. But because it's not in the cookbook, you may get some disagreement about what it means between experts. It's kind of like grandma's recipe.
Is butchering this.
But what I expect you'll hear is, it's important for people who don't have experience in certain abusive relationships that are violent to understand the control that can be exerted over an intimate partner by the other one, isolation, psychological violence, emotional violence, physical violence, sexual violence, which I suspect will be described to you as well by the defendant, perpetrated on her by the decedent. You'll hear about all this. And what it ties into, at the end of the day, after we talk about this during jury selection, is if there is a self-defense instruction read to you, this is to help you understand what an objective and reasonable person in the circumstances would do. Because years ago, we've gotten better as a society. Years ago, when this was first being researched, the question would be, well, why don't you leave? And battered spouse syndrome, and the testimony from these experts help explain those things to people. Well, it's not that easy. You got to look at what's going on in the relationship, isolation, control, so on and so forth. And that explains why you wouldn't leave. Well, now, returning to the facts of our case, what you're going to decide the facts are is ordinary, objective, reasonable person in those circumstances taking those actions if you get self-defense instruction as part of that. That's what it's used for. It's not used for explaining the subjective beliefs that one holds. What you will also hear about these things is, just like any other doctor or any expert, like a home inspector. If a home inspector's report was based solely on the person who's trying to sell the house, what they say about the house, great shape, I rewired the entire thing, brand new JDC pipes, this sucker's good to go. I agree with this, isn't that one? You're not going to take that home inspector's report unless they lift the hood, take the tires, do all the things that the box on here, in the Carfax does. If you want an expert to get reliable information, an expert's opinion is only as good as the information he or she finds out. They will say, yeah, you gotta take into account credibility of the person who's taking the story, even if it's the patient or the client that is saying all these things happen to her. You gotta find proper information, you gotta check reliability, particularly the circumstances that we discussed. Another thing that they're going to tell you is, just because there's a bunch of violent nonsense going on between 2 intimate partners, doesn't mean that it's not syndrome applies. Some people can go home and fight like
He's arguing this is not stuff that belongs in an opening statement.
there's like spins like that. So just because you hear about those things, what the experts will tell you, doesn't mean that it necessarily applies. If this testimony comes in, I expect that Dr. Harp will say that it applies to the student. We'll talk to her about what she relied upon to make that conclusion. We'll talk about some other things and take that journey together. But at the end of the day, after you hear all of the evidence in this case, particularly straight from the horse's mouth, the video, where you don't have to rely upon the credibility of anything other than your own 2 eyes and your own 2 ears, the statement that you're going to return guilty verdict for second-degree murder. What the evidence is going to show is that the defendant killed Mr. Torres because she decided he deserved it. Not because the evidence will show an objective, reasonable person in her circumstances. Thank you.
Thank you, Mr. J.
All right. I know that was really difficult to hear. Now listen, I'm going to give that a grade of a C. He went into a lot of technical stuff. He went into a lot of minutia with the law. He went into even some argument about whether or not he agrees with battered spouse syndrome. I mean, the way that you present that in an opening statement is something like this. You might hear a story of something called battered spouse syndrome. Battered spouse syndrome. It is a syndrome that is akin to PTSD, the result of various and numerous and continuous and pattern-laced domestic violence incidents that affect your judgment. However, it is a self-defense theory. You're going to hear, if you hear it at all, you're going to hear that it is a mechanism to justify self-defense. The problem with that is you're never going to see on the video or through testimony any evidence that Miss Boone was ever in danger, imminent or otherwise, you're going to see that this imagined offense that she's trying to put forth is a figment of her imagination, because she's been backed into a corner because her actions have led to this man's death that implicates her for murder. And it is her only attempt to be able to justify what happened. But you're going to see, as the evidence will show, that these people were mutually combative, that these people had domestic violence incidences on both sides. And what you're not going to see is any overt act that Mr. Torres ever committed while sitting there in the suitcase that placed Miss Boone in danger. And for that reason, if you hear something related to battered spouse syndrome, you have to remember and keep in your mind that it is utter nonsense. And if it's utter nonsense, there's only one way that this case would go. Thank you, folks, for your time. Something like that. But he's too technical on the details with that. Look, it might be nerves. It might just be that's a style, whatever. But in my opinion, he was trying to teach way too much the jury about this rather than give a brief narration of what the evidence was going to display, what to look for. Because once you put in the jury's mind that, look, the overt act thing, it has to be there, otherwise it doesn't work. He doesn't have to teach them that, but what he does have to do is get the jury to, with a eagle-eyed focus, fixate on whether or not there was an overt act, because that's going to be dispositive of the case. No overt act, no battered spouse syndrome, only one conclusion: guilty, right? But he goes on to try it another way. So let's see what this defense, I'm hoping that we can hear him a little better than this other guy.
Defense.
Judge, can we invoke the rule?
I've already advised the witnesses.
Okay, the rule of sequestration will be invoked. Thank you. You may proceed, sir.
Ah, shit, he's going to stand over there. All right, I'm going to try to turn this up as much as I can.
Between Sarah Boone and George Torres.
Thank you.
Sarah Boone and George Torres were down and out, as you can be. Their lives centered around alcohol. Both of them suffered from, used to be called alcoholism, now it's called alcohol abuse syndrome. And so day to day, they struggled with the use of alcohol. You can imagine that. It affected their jobs. It affected keeping employment. It affected even getting a job. As codependent as you can be towards each other. And you're going to learn, with all that, was domestic violence. And that George Torres physically abused Sarah Boone. And she suffered from the effects, the psychological effects that one suffers from repeat violence from an intimate partner. They were together over 3 years, and there were several prior incidences of violence. We've got the photographs. There were incidences where police were called who took photographs. So you're going to be able to see the evidence. And we believe the court will instruct you at the end, when you're considering self-defense, which we call justifiable use of non-deadly force or justifiable use of deadly force, that you can consider the prior acts, the history of violence, the prior difficulties that the parties had, and considering her set of circumstances that she was faced with in making the decision to use reasonable force under the circumstances. And the most important thing I can tell you here today is keep an open mind. There's two sides to every story. You're going to hear the state's side in attempting to paint her a certain way, as they've done here today in opening statement. And then you're going to hear another side. And you're going to have to weigh that, all the evidence, the credibility of the witnesses, the photographs, the videotapes, and come to a conclusion. Now let's talk about this day, February 23rd of 2020, the date of this event. This case has been pending for some time. Here we are, October of 2024. I think the evidence is going to show that they had purchased some wine the day before, but they hadn't finished all of that. So it was in the refrigerator. Many times that's how they start their day. At some point, you're going to see a video from Publix, from where they live. I believe it's Winter Park. But Publix was not too far from their apartment complex. And they took their car, they drove over there. So you're going to see a videotape from Publix of them both going in the store about noon, and they come out with one of these larger bottles of the wine. And then, of course, there's a receipt, and the bottles are in the garbage can. Of course, there obviously is an attraction between the two. And as everybody knows, couples can have great times where things click, everybody gets along, and then we can have episodes of disagreement. And how are those resolved? Really, that's what this is about. How are disagreements resolved? But George was very jealous of Sarah. And you're going to hear the testimony about that. And that he cannot, in certain situations, he can be very charming. But when his level of intoxication gets to a certain level, is when he gets sad, moody, and a lot of times eventually it involved forcible sex with Sarah Boone or actual physical violence against her. They bought the wine. It's a simple life. They don't have much money. But they both like art. They did that for a while. They both like puzzles. They did that for a while. Well, about 5 or so, the wine bottle was gone. And George had said, I want to go get some cigarettes. So there's a convenience store right close by their apartment complex. And Sarah thought he was just going to walk over there and get cigarettes and come back. But no, what he did was he got her keys, he got her debit card, and he went over to the Publix and he got another bottle. And I think that was about 5:30, something like that. And again, there'll be the Publix video showing him going in, going out, and there'll be a receipt for the purchase of that bottle, and then there'll be that bottle. It'll be in the garbage can along with the other bottle. Well, when he comes in with the second bottle, Sarah knows. This is not good. She knows this means he's going to get to another level.
Oh, this is such a bad idea. Why is he doing it like this?
So Sarah's concerned. So she attempts to placate him, keep him busy, keep him in a good mood. They drink that bottle, but she drinks as well. And at some point, they're intoxicated at a high level. As some people do when they're drunk, they get silly. And they decide to play a game of hide and seek.
As you
She
do
goes upstairs
on Thanksgiving.
to the shower and waits for a period of time. And he doesn't come to her. At some point, she gets cold, she gets tired. She wants to go see, well, maybe we got it mixed up. Where is he? So she goes downstairs, and they had gotten a suitcase down a week or so ago. It's an old suitcase that they were going to donate to Helping Hands or Goodwill or somebody, and they were putting some items in there. And it's a broken down suitcase. It's a large suitcase. They both weigh about 100 pounds. And they don't eat good. Malnourished to a large degree.
She does not weigh 100 pounds.
But the pull handle is broken off. And they've attached a little paper clip that's got the rubber around it, and that's how they move back and forth. Well, as she comes down the steps, she sees him getting in and settling in the suitcase. So she walks over there, and they see each other, they smile and laugh, and she zips him up. And she zips him up, and they laugh for a while. And they carry on. She sits on the couch, and at some point he says, I can't breathe. Now, his face is facing the zipper, and she's got 2 or 3 inches that she's opened it. And she doesn't know. They're intoxicated. She doesn't know whether he's just saying that to try to get her to get him out or what. But he's a captive audience. Physically, they're the same size, but he's much stronger than her. If they got in a fist fight, he would win 100 times out of 100. But she's got him now. He claims he can't get up. He has to sit and listen. It's a unique form of physical restraint. And so she lets him have it. Says things she shouldn't say. You'll see the video. It's about 2 minutes long.
Commits felony in the act.
Turns her phone on and videotapes it for about 2 minutes. There's another video that's approximately 11 minutes later. The first video, George is, the suitcase is flipped upside down. The zipper's off. 11 minutes later, Sarah has flipped it right side up. Again, open for him to get out. And it's only 22 seconds. And you hear George say, Sarah. And that's it. Now, the key to the case is that 11 minutes. And what happened during that 11 minutes. Okay? That is the key to this case. Sarah Boone will take the stand. She will explain what happened. She will explain why it happened. The evidence will show that she was justified in the action she took to prevent an attack from Jorge Torres.
And by the way, she has to take the stand in this instance because there's no other way to lay foundation that there was an overt act. She was the only one in the room. So where you're supposed to have a Fifth Amendment right to not incriminate yourself, she's being forced to take the stand by virtue of her chosen defense.
Which the law acknowledges that every one of us has a right to invoke, the right of self-defense. You can hear from the medical examiner. She is going to tell you about some bruising on Jorge Torres. Of course, he was in the suitcase a while, deceased, we believe. And that changes things a little bit, as the medical examiner will explain. But there's some bruising. Sarah's going to explain that to you. Why that happened. What were the circumstances surrounding that? Involving the back. Her son comes and stays with him from time to time. He has his own room. He has several of his things there. And there's a bat downstairs. The same bat that Jorge Torres used, and there's a video where George is threatening Sarah. And he's swinging the bat at the TV about as hard as he can. And he does it about 6 or 7 times. You'll see it. Sarah's recording it. And it's during an argument. And he's trying to intimidate her. Sarah loves you. You know, you're going to hear why women don't leave. Why women don't leave. And you're going to hear about Sarah Boone and her struggles, her mental health struggles. Sarah had no intent to kill. The prosecutor mentioned she wanted him to die. Farthest from the truth, she loved the man. She hated the abuse. She couldn't leave him. She tried. She tried kicking him out 6 or 7 times. He kept coming back. She changed her locks. He kept coming back. She didn't have the family. She didn't have the support. She was weak, vulnerable. You're going to hear it all. You've got to take that all into account to try to understand what happened and the circumstances surrounding this tumultuous relationship. Now, you can find that Sarah's not perfect. And, you know, she goes, as many of us do when we drink too much, and you sleep in. She slept in. 11, 12, 1, somewhere around there. She moseys downstairs looking for George. She thought he was on the computer looking for a job. She looked outside, maybe he's out smoking a cigarette, and she sees the suitcase. She unzips it. She gets him out. He's purple. She tries her best to do some CPR. She freaks out. The only family she's got is her ex-husband, really. She relies on him. As the prosecutor said, a lot of times she'll flee to her ex-husband's house. And where her son is at? Lucas. The only thing she knows to do. She's kind of a sheltered daughter when she was younger. She's smart, but she's not worldly. She calls Brian. What do I do? He said, I'm coming up. Please come up. He's about 5 minutes away. And she calls him again within a couple of minutes. Yeah, I'm on the way. He gets there. He walks in the foyer and sees his legs. And she called 911. She calls 911 within a minute. Detective Rodriguez arrives. You know, they got the body cam now, so it's recording. So you're going to hear Sarah talking. But Sarah's freaking out. Sarah's thinking, and I'm somehow responsible. Eventually, she gives a statement to law enforcement. She gives one to Detective, or Deputy Rodriguez. Of course, she's not the homicide investigator. She's just responding. She's the first responder. And, they know what to do. They try to assess the situation. They start putting the tape out. And then they call for the homicide investigators to come, which takes a little time. So she gets a statement from Sarah. Eventually, the homicide detectives get a statement from Sarah and one of the unmarked SWAT cars. And it's recorded. You may hear that. And then the next day, they take Sarah's phone. Sarah gives them the phone, signs the consent to take the phone, and take it to, they have a phone extraction people at the sheriff's department, where they can take out all the data, all the phone calls, text messages, photographs, videos, all that. And they find these two videos. Sarah's not aware. She doesn't remember making the video. You can imagine. Gives them the phone.
He
She
didn't.
makes no attempts to do anything other than, here's the phone. So they tell her, you're going to get your phone back tomorrow. We'll bring it back to you tomorrow. Well, they end up having a conversation with the female detective, homicide detective, Costle, is her name, Chelsea Costle. And they end up, Deputy Costle was pregnant, or Detective Costle was pregnant. So they end up, hey, we're not going to bring your phone. I'm not feeling good. Can you come to the sheriff's department? Which Sarah Boone was telling you, that was where I was going. That's what they told me I was going to the sheriff's department for. Well, instead, it was an interrogation. And they were going to arrest her. They made their mind up on it. And they were going to confront her and try to get her to confess based on the two videos. And so there's approximately a 2-hour interrogation that was on the 25th in the afternoon when she got there to get her phone. They said, well, we got to come up here. We need to talk to you. And they got her in the room. It's a small room, but it's being videotaped and audio taped. And it goes on for about 2 hours of them trying to get a confession to murder. And it doesn't happen. But Sarah lies. She's scared. She can tell they're trying to pin her on this, that this was some kind of intentional act, and it was not. So she lies. She's not a lawyer. She doesn't know about self-defense. She doesn't understand she has a lawful right to defend herself. She doesn't understand that she's justified in using the force that she used.
That's what he's going with? That's Jesus Christ. I apologize. Let me let him finish. He's going to wrap up pretty soon.
She doesn't. I wasn't there to advise her. No lawyer was there. So she lied. And you're going to hear that. So you're going to have to balance that versus her taking a stand and testifying before you. And we simply ask that you look for the evidence of cooperation of her testimony. It's going to be later, probably next week. The judges will tell you in reading instruction on evaluating a witness's credibility. And they'll talk about warrant and evidence, other evidence that's consistent with the testimony that Sarah Boone gave. So you're going to have to weigh that in her testimony. Now, self-defense, we talked about it in jury selection, usually a gun, some deadly weapon. The suitcase in this case was a physical restraint or a blocking of an attack. But it was unconventional. Self-defense, nonetheless. Now, as I said, the struggles that occurred, many of them involved police. So you're going to actually hear from some of the police officers. Maybe some body cam footage. You're going to see some photographs that they took of the injuries to Sarah Boone. And some of the videos you may see of her in a very happy, joyful type of thing. Well, number one, she's intoxicated. Number two, she's safe. Police are there. So her attitude is not one of distress. We're here today, it's full, packed courtroom. That's great here, but you're the most important people. Because you've got to decide this case honestly, fairly, and according to the law. And we talked about the two biggest principles from the Constitution that apply. In this case, and in every case in which a citizen like Sarah Boone is brought into a courtroom and accused of a crime. The first is, you as a juror must presume or believe
I was going to do
Sarah
this whole thing.
is innocent. And that belief stays with you throughout the entire trial. Because of that, she doesn't have to prove anything. That's why the state went first in jury selection. That's why the state went first today. That's why the state will go first putting on their case. They have the burden of proof, and it's the highest burden we recognize in any type of litigation in this country. Proof beyond and to the exclusion of every reasonable doubt. You are going to have doubts about this case. But the most important thing is not to rush to judgment, to keep an open mind, and understand there's two sides to this case. There's their side and there's our side. So you can't form any fixed opinions early on. That's hard to do, as Mr. Henderson said in jury selection. That's extremely hard to do. Now you're going to hear some testimony. Just been mentioned next verse. Battered women's experiences affect her perception of imminent danger. Battered women's experiences affect her perception of imminent danger. Victims of repeat violence may fear death in a situation others would not. After hearing both sides of this case, we're confident you're going to have a reasonable doubt. And we're going to ask you to follow the law and do justice in this case. And find Sarah Boone not guilty, because it's the right thing to do.
Okay. So, if I'm great, look, this might be a hot take. Because I understand how people are perceiving this case. And look, you guys are, if you're following the Sarah Boone case, my guess is you've been familiar with this case for a period of years. But you have to believe that there's 6 jurors sitting on the panel right now, and presumably they don't know anything about this case. I don't know who Sarah Boone is. Not everybody knows who Sarah Boone is. When I talk to people about this, I talk to people about all kinds of cases because they know about my channel and whatnot. They always ask me about my channel and the cases I'm covering. When I talk about Sarah Boone, I'm shocked about how many people don't know about it. So you have to take this from the juror's perspective. They know nothing about the case. And so my grade for the defense attorney is going to be based solely on this. I thought that his presentation and his relatability was superior to the DA's. I do. I think that I would give him a B- to a B in terms of what he did with what he has to work with. And look, I'm going to do things like, oh, this is how I would have done it, and this is how I would have presented the opening statements. And look, I'm not the arbiter of perfect opening statements. But my opening statements would have been something like, this lady has endured years of abuse at the hands of Mr. Torres. There was a history of abuse spanning years. There is a history of her being experiencing severe injuries at the hands of Mr. Torres, facing severe consequences whenever she pissed this guy off. So for right or wrong, when she sat there, and you're going to hear testimony, the fact that they were drinking and that she was inebriated and he was inebriated, you're also going to hear that whenever he was inebriated, he became whatever he was as a sober individual went out the window. When he was drunk, he became a demon. And what Sarah Boone believed was lurking in that suitcase was a demon, such that if she were to let him out and he were to, with nobody there to defend her, have her way with her, then her life was in peril. She knew that this game had escalated beyond something that was reasonable, but there's nothing she could do about it. Now she's in a position, as the evidence will show, that had she had left him out of the suitcase, he would have potentially taken that baseball bat and obliterated her face. You're going to hear theories about the battered spouse syndrome and whether or not it's a viable defense and whether or not she was actually defending herself. The evidence is going to point to the fact that had Torres been allowed to exit the suitcase, then he would have potentially murdered her. And I would have relied on that because that's their defense. It might be stretching the theory. It might be stretching the theory of the case and their defense. And look, you might have to really squint really hard to connect the logical dots, but that's what they're arguing. And so I would try to use descriptive theatrical language to impress upon a jury that this person, no matter how slight he was, and he did mention it, look, he would win in a fight 100 times out of 100. You know, weight classes be damned. He was stronger than her. And there was a history there. Sarah Boone knew that if she let him out of that suitcase, her life was in peril. Thus, self-defense, thus, battered spouse syndrome, thus, not guilty. Something to that effect. I'm not saying it's the perfect opening statement, but that's essentially what their argument is. That's how I would have presented it. He didn't do that bad of a job, to be honest with you. If I'm judging just purely, in my opinion, purely off of relatability, it's often the times It's often the case that the defense attorney is more charismatic and relatable than the prosecutor. And the reason for that, there's a lot of reasons for that. One of them happens to be that they're in an office that is in the practice of passing judgment against people, and people that pass judgment usually talk in a certain kind of a way, and it's difficult to relate to somebody that wants to judge everybody. Just off the bat, it's not his fault. It's just the nature of practicing criminal law on the prosecution side. So I thought that he was more relatable. Now look, he's got severe problems with the evidence in this case. He's going to have to overcome an awful lot. But I thought that he may, because look, he said he got one thing wrong and that he doesn't have to prove anything. By virtue of the pretrial motions, he's going to have to prove, at least by a preponderance of the evidence, that there was an overt act where she felt she had to defend herself, and the actions that she undertook were as a direct result of her subjective fear of imminent harm or danger. Now the prosecution is going to say, oh, the reasonable person, and he's going to extend that. Well, a reasonable person would know after years of abuse, if he gets out that suitcase, she's dead. She's good as dead. Alcohol, he's really bad when he's inebriated. They've been drinking all day. He's really pissed off because of the stupid things that she's done. And look, he's not saying that Sarah's a saint. He's just saying that, look, there was an overt act. She felt she was in danger, so she acted like she did. It's not a perfect defense at all. It is not. It is not. But that's the case he has. He's doing the best that he can with the facts that he has. He chose this defense, so he's rolling with it. So it was the danger. If you go with battered spouse syndrome, this is what you're facing. And now here we are. So, look, do I think that the case favors Sarah? No, I don't. I think that this is a pretty simple case. I think that the prosecution is going to make light work of this. I think that they're going to get a guilty verdict out of this. I'm just saying that I, in some ways, empathize with the defense counsel's position in that he is had a month to sit with his evidence, and he's doing the best he can with a very difficult client. Look, he voluntarily took on this case. It's his own dumbass fault. But with what he has to work with, he's representing her. And interesting, you're going to see that at the conclusion of testimony today, the judge asked her point blank on the record, do you have any problem or issues with the way that your defense attorney is representing you, their theories of the case? Sarah says no. They did that for a couple of reasons. One of them is so that she can't appeal based on ineffective assistance of counsel. Look, her counsel is competence. Whether or not you think you want to judge him because he's got a bad case, I'm seeing different things. I'm seeing he is a relatable defense attorney. He's a good attorney. He knows how he's not intimidated by the facts of his case, which is a good thing. Oftentimes you'll see attorneys that don't want to take cases because the facts are well in the other side's favor, and they just don't want to look like a dumbass in court, so they're not going to take the case. This guy does not have that fear, and that's a good thing for Sarah. I had originally opined back about a month ago when he sat on the case that I thought he was a really good attorney for Sarah, and that I thought that as difficult as the case was, he's the kind of guy that you would listen to and at least hear him out before passing judgment. The other attorney is really good as well. We haven't had a chance to see him yet, but those were the opening statements. There's going to be, I'm going to cover today's testimony later on today when everybody's had a chance to catch up. I cannot do gavel to gavel coverage because I have an active law career and I just can't. I got to run my law firm. So in the evenings, if you're a member of this channel, you'll be able to see me live in my live analysis of these cases. They're going to be presented as edited videos for those that just don't want to be members. That's cool with me. There will be no paywall there, but we're going to analyze every step of this case. I'm interested in the case for a couple of reasons. Obviously, the facts are very salacious and they're entertaining and all of that. The other one is that these attorneys' styles is going to be a master class in differing approaches to difficult facts. You have a prosecutor that thinks that this is a slam dunk. He's been thinking it's a slam dunk for 4 months or for 4 years. You have a defense attorney that's coming in to save the day. He has nothing to lose, man. He's got nothing to lose. He's an older attorney. How many more years is he going to practice? How many more criminal trials does he have in his back pocket? This is his big chance at fame and having some measure of fame as a result of his prowess as a defense attorney, he's going for it. Whatever, he's going for it. It's like Mick when he wanted to be the corner man for Rocky in Rocky 1. And Mick is like, I'm 76 years old. This is the only chance I'm going to have at a heavyweight championship. And he's appealing to him. I look at this defense attorney the same way as I look at Mick in Rocky 1. Dominic, tell me you know what Rocky is.
I know what Rocky is.
Thank God. So look, this is going to be an interesting trial. I'm going to be providing summarized coverage of this as it goes on a daily basis. This is day 1. These are opening statements. And so that's it. What do you guys think? Who would you trust? You've seen these two attorneys. Now, look, it's kind of skewed because you couldn't really hear the DA when in his presentation. They sort of fixed the mics for this defense attorney so you could hear him better. Just my takeaway is that I think that he suffers from the DA syndrome, which is trying to present a clinical case and going through every nook and cranny of all the legal theory and all the whatever, all the receipts. They have to do that, but they have to also balance it. This guy is an average DA. This defense attorney, I don't know if he's average or above or below average. I just know that for his opening statement, he's done a good job with what he has. I give him a B. I give the DA a C, but I still think that it's going to be an uphill battle for Sarah to defend this case. I still think that she's going to be convicted of second-degree murder, carrying a minimum of 22 and a half years in prison. She screwed up. She should have took the deal. My understanding is that this defense attorney took the case. He tried his very level best to try to get her to accept that plea, and she refused. So here we are. We're in trial. All right, folks, that was opening statements of the Sarah Boone trial. At some point later on this weekend, there will be coverage summarizing the witnesses that testified today on day 1. Trial's going to resume after some testimony was taken today. On Monday, and then we will resume our coverage of it then. For all the rest of you, we're going to get ready for some family law after dark. I got a multitude of guests joining us, and we're going to have a real good time. So ready your beverages. It's going to get real crazy. We have all kinds of crazy cases. There's this guy that sent his son to live with his mom for making homophobic statements. There's a guy that wants to divorce his wife because she was salsa dancing with another man. There is another guy that the girl wants to divorce him because she feels that he didn't stand up for her as they were being robbed. I got lots to say about that, and other shenanigans. The Schnitzel might be joining us. Lauren Knighty is standing by, ready to join us. Bruce is coming in. Brad might join us if he is done with his walks or whatever he's doing. And other guests. So I love you all. I will see you over there. Hey, Dominic, have you linked to the flag?
Yeah.
All right. Bruce is ready. His antlers are ready. I know Jules is going to be over there for sure. Liz with her mega pints. We'll see you guys all over there. Love you all. Bye-bye.